आवाज चालू झाली. आवाज बंद होते.
आता आता आवाज जात आहे. म्यूट जाते.
म्यूट म्हणजे हा
आवाज येतोय सर आता तुमचा.
येतो ना आवाज?
हो येतोय सर.
बर, सुरू करायचं आहे का मॅडम?
हो सर, आता लगेच करते.
बर, ओके.
A very good morning to all of you. A very warm welcome to all our participants, our guests, and highly esteemed speakers. Welcome to the national webinar conducted by VG Shivdare College of Arts, Commerce and Science, Sholapur on IPR and patents, frontiers and opportunities. Before we begin, I would like to start with a small lamp lighting ceremony And for that, could I please request everybody to observe a minute of silence? Thank you so much, everyone. And as wishes, I would like to start our seminar. Can we, before we begin, I would like to invite our principal, sir, Dr. B.N. Kamble, to please introduce this session. Sir, please.
Good morning, one and all. Good morning, one and all.
Good morning, sir.
Good.
It gives me an immense pleasure to welcome all the dignitaries, participants, researchers, and students on the occasion of national webinar on the topic IPR and the patents, frontiers and opportunities, organized by Department of Biotechnology at the DSTS Mandal's VG Shivdare College of Arts, Commerce and Science. Intellectual property rights is an huge area of importance in every field of knowledge, innovation, and technology. Appropriate accreditation, registration, and protection under law of many novel ideas, innovations, and technological enhancements has always remained a concern for its socio-economical applicability. Intellectual property rights and patents help in the most efficient way to ensure fulfillment of these objectives. To understand the comprehensiveness of the field of IPR and the patents, one needs to understand the fundamental aim, regularity aspects, process involved, as well as challenges before the research and development. In view of the same, we have selected this important topic for today's series of webinar. In consciousness of this importance of this topic, which is not limited to any particular stream, we have encouraged participation, students and researchers from arts, commerce, and science faculty. And to guide us on this topic, we are very fortunate to have with us Dr. Ajay Thakur, who is an assistant controller of patents and design, Government of India, and Dr. Raju Tagar, who is the founder and head SciCap Biotechnology, Mohali. Here I would especially like to mention and thank our first distinguished speaker, Honorable Dr. Ajay Thakur, who has agreed our request for the second time in continuation after being available for a national conference organized by our institute in the year 2020. Friends, we are really grateful for this kind availability for the sake of students, academicians, and society. I also welcome our another distinguished speaker, Honorable Dr. Raju Taggar from SciCap Biotech, Mohali, Punjab, a reputed multinational institute with which very recently our institute has established a MOU. We look this as a great start with him and are really looking forward for the student and research centered activities in collaboration. I also would like to appreciate the efforts taken by our faculty, which has been very consistent teamwork since years in organization of such wonderful events. All the faculty members are working hard to maintain the same tempo even under the challenging situations of pandemics prevailing from the last couple of years. Once again, I welcome you all on this virtual platform and wish you best of luck. And I hope that this national webinar will become very fruitful and beneficial in enlightening the knowledge about the intellectual property rights, which will be very much useful for the students, for the researchers and the academicians to go forward in their research work. Thank you very much.
Thank you so much, sir, for those kind words and introducing the seminar to all of us. Can I now please request the principal of our sister college, Dr. R.Y. Patil, sir, to please bless us with his blessings. Please, sir.
Good morning, everybody. It gives me immense pleasure to join this gathering of research-minded students, faculty, and the experts like Dr. Thakur. Dr. Thakur is an authority on this topic. I have heard him, I had an interaction with him when I was serving the Solapur University, now called Punyashloka Ahilya Devi Holkar Solapur University, Solapur. So, few words to my young fellow scientists, students who are the future of this arena of research. My dear students, the days when India was having only the process patency, and in the process patency also, in fact, we have done exceedingly well, and we have done so well that even the original inventors had to come to us for purchasing their product with a different process. No doubt there are some issues of discussion there. Then second era started when the world was forced to come and in fact, early process was only for 7 years, and it is now product patency, that too for 20 years. And in this era, in fact, a few years back, if we go in the academics, the saying, or people used to say that you publish or perish. A situation that has changed. Don't publish, keep it a secret, see if you can patent. Now it is more than publishing. Patent, if you are not able to patent, probably you will perish as a researcher. There are again two ways or two views. When I say it is my intellectual property, in Indian context, in Indian culture, we don't believe that my intelligence is my property. Because when I am born, I didn't have a hospital built by me to be born in that. I use the hospitals of the society. I use the libraries of the society. I use the existing established institutions, and I have developed my intellectual property. And in Indian culture, we say this cannot be said mine, because there are so many entities which have played their roles for me to develop as a scientist. So this is another stream which our Indian culture taught us. But now, for the young generation, we had excellent scientists called Rishis and Munis. We had excellent initiation of the concept of universities in this country. We are the ones who had tens of thousands of foreign students serving here, studying here, and doing the research. So my dear young researchers, you have excellent speakers now. Have wonderful time. Enjoy learning, may it be trademarks or whatever it is. You go into details and develop that culture of patenting and prospering. I wish the webinar a grand success, and I appreciate the efforts from the institution and the energetic staff. I congratulate all the members, principal, members of the staff who have taken initiative. And I once again, on behalf of all of us, wish you all the best and congratulations. Thank you very much for giving me an opportunity to be part of it. Thank you. Over to Dr. Chitra.
Thank you so much, sir, for those kind words. And thank you for reminding us of our cultural heritage and our attitude towards what patenting should be. Thank you so much, sir. So with that, I would like to invite our first speaker, Dr. Ajay Thakur. And to introduce Dr. Ajay Thakur, could I please request our professor, Mr. L.R. Gote, to please introduce our first speaker. Gote, sir.
Yeah, ma'am. Thank you. So, very warm welcome to everyone and all once again. It gives me immense pleasure to introduce and welcome today's resource person, Honorable Dr. Ajay Thakur, sir. I'm happy to say that sir having a strong educational qualifications. Sir having multiple PG degrees like MSc in biochemistry, PG diploma in business management, Master of Management Science from Pune University, and sir achieved a MPL and PhD in marketing management from the same university. Also, sir completed their LLB and LLM in IPR and information technology from Mumbai University. I would like to focus on sir's work experience. Sir worked as a senior scientific officer in Hindustan Antibiotic Limited, Pimpri, Pune. Also worked on a deputation with RPG Life Science. And I'm very happy to say that Sir currently working as a assistant controller of patents and design in Indian government. And other than this, Sir provides a training on different topics like research methodology and the production of banana cream from banana wastes. And Sir attended trainings in India as well as abroad like US and Japan. And Sir conducted over 500 patent awareness programs in various industries, universities, and colleges, schools like this. So I'm really very happy to welcome such an eminent person as a guest and speaker on this wonderful program. So thank you so much. So to Chitra ma'am.
Yes. May I please hand over the mic to our first speaker, Dr. Ajay Thakur, sir.
Good afternoon.
Good afternoon,
Am I
sir.
audible?
Yes, sir, you are.
Yeah, okay. Respected dignitaries, Kamble sir, and Dr. Patil sir, then Gopika madam, Chitra madam, Gote sir. I am very much familiar with you, and it gives me an immense pleasure to be part of this program, as I cannot reject the proposal sent by you for conducting a webinar on intellectual property rights and patents. So let us not waste any single time or single minute on these. Let us start with the what is intellectual property. I suppose in the introduction part, it has been told me that there are some art students, commerce students, and even science background students are there. So let us focus on just briefly summarize what is intellectual property, different types of intellectual property. Then we will go to patents, what is patents, patent filing process, and what kind of patents are patentable and what kind of things are not patentable. That we will discuss throughout this session. So intellectual property right. So what is exactly intellectual property right? Intellectual property right is nothing but the right Okay, so intellectual property right, it is a collective term for intellectual property rights. So in short, we called it as an IPR. So intellectual property broadly is qualified into two types, that is industrial property and then copyright and trade related copyright and related aspects of copyright. Now, as far as industrial property is concerned, it includes scientific, literary, scientific and scientific work that includes patents, designs, then geographical indications, and trademarks. All these are nothing but the industrial properties, as well as we have come across the term copyright. So copyright and related rights are nothing but the rights which are mostly related with books. So people in many streams, I find they are confused with. So, see, a simple question is being asked. Ki, I have published a book. I have a book. One simple thing. And somebody comes and tells me, I want a patent on that book. So basically, you should understand what kind of domains are registered under this intellectual property rights, which are broadly classified under classified as patents, designs. Okay. So basically, they are qualified as patents, trademark, copyright, trade secrets, then geographical indicators, finally plant varieties, and that are covered under these things. Now, what is intellectual property? Intellectual property is nothing but the property which is the result of human intellect. Human brain thinks of something, and then that property or that brain or that idea is converted into something fruitful or something product or a process or something like useful product that becomes the intellectual property. Now, what is intellectual property? So intellectual property is nothing but the result of human intellect. Human brain thinks of something, and for example, if you come across any television or mobile phone, was it in existence? Everybody uses mobile phone. Everybody sends, everybody uses WhatsApp, Facebook, and all the things. But how it works? Nobody is known. You can send messages, you can call, you can email, you can do whatever, lot of activities with the mobile phone. But how these functions work, what is there in that mobile phone is not, people are not aware of, or people are not aware of. But that is nothing but the intellectual thing. That is the hidden thing which cannot be seen by naked eyes, but it is present, and because of it all these functions work. So basically intellectual property right is nothing but the right which is the manifestation of the human thinking, human result, human ideas, and that creativity is known as creativity which we deliver is recognized in different forms of intellectual property. As they are commercially tradable, so we call them as intellectual property. Nothing is there, only brain investment is there. It is only the because of brain, it is only the because of ideas, different brain thinking mannerism in which the person thinks, and the activities or ideas which he puts into either any form, right, a book form, or a design, or instrument, or any other sort of useful product which is useful for society and which can be traded. So it should be commercial. So commercial in the sense it should be able to be we should be able to sell it out. Now this is nothing but the intellectual property. Now intellectual property, you have come across this kind of symbols. Have you come across this kind of symbols?
Yes,
sir.
sir.
So these kind of symbols denote that this material is copyrighted material. What is copyright? Does that mean you have the right to copy? Can you copy somebody's?
No, sir.
No.
You don't have the right to copy. It is the right on the copy. So it is a copyright. Now, when it comes, copyright is a legal term. It gives the creator of the literary. Now, mind you, please make it clear that after this session, you should be able to recognize which sort of thing is registrable under which domain of intellectual property. So when the question comes up, intellectual property related with copyright. So what is copyright? You see, where you see these kind of words, mostly on books, cassette players, CD players, or some literary work, artistic work, paintings. You see this kind of work. So this is the work which is the creator's work. So that creator's work is being protected in the form of copyright. So copyright literally means literary, artistic, musical, dramatic work. So when you come across this kind of things like literary books, then any films, dramatic version, adaptation, musical work, artistic work, sound recording, all these domains fall under the jurisdiction of copyright. All the intellectual property rights are governed by some statute, and they are protected under the different statutes. So for example, if you see literary work, now you cannot say I want to patent my literary work. Literary work which includes books, newspaper, question papers, catalogs, dictionaries, lecture reproduced to writing, computer software, computer program, all these kind of work. When it comes to registration, whenever some author or some person creates this kind of book, it is essential that he should know that he should file. He should not go and file application for patent, but he should go and convert this work into a copyright material, right? So whenever somebody asks you, I want to patent my book, you make him clear. Now, patent cannot be granted to a book, or patent cannot be granted to question paper or newspaper or catalogs or dictionaries or any computer software program. They can be only copyrighted. So is that clear? I am telling this because there are many art people who are working in, who are studying literature and many other novels and many dramatic presentations or dramatic dramas, and all these works are included. So because these people should know that this kind of material is only protected under copyright. Then artistic work, then painting, chart, all these kind of work, advertising, posters, industrial designs, and all that thing comes under the copyright work. Then musical work, all musical songs, lyrics, all the choreographic work, and all that comes under the musical work and dramatic work. Then broadcasting right. Broadcasting right, again, it is the right which is the channel occupying the serials or the channel which is taking the rights. Now you see Kapil Sharma show, CID.
Yes, sir.
So Kapil
Yes,
Sharma
sir.
show is seen on only
Sony TV.
Sony TV, right? But it is not seen on Colors TV because they have protected the right against the broadcaster, and the broadcaster is nothing but the Sony TV who has taken the rights of the show, and therefore this show will be seen. But if anybody tries to show this show on Zee TV, it will be infringement of the copyright, right? So these rights, again, I tell you, these rights are for a specific terms. Some like broadcaster right is for 25 years, but writer's right is for around 60 years after the date of his 60 years up to the date of his the person who has created that the artistic work. Then again we have performers right. Then there are many case laws, but right now we are having a shortfall of time, so we will have to complete all these things. Then so just basically understand, when you come across books, textbooks, all literary, artistic, dramatic work that is registered under the domain of copyright. Mind you, it is though not necessary, but it is always the idea which has to be expressed in form of books, novel, or any other articles of commerce which can be traded. So these things are nothing but the copyright material, and then therefore they are covered under the copyright. Then another claim I come across, trademarks. Have you heard the word trademarks? Have students heard the word of trademark?
Yes, sir.
Yes, sir.
So what are trademarks? Trademarks and service marks are distinctive symbols that help to help the customer to distinguish between the competing goods or service, and are a major part of goodwill of a company that enjoys in the trade. It is nothing but the goodwill. What is now, for example, if you go to market and your mother says, or somebody with you says, go and buy a go and buy a bottle of mineral water. What you go and say to the shopkeeper? What do you go and say? Give me a bottle of. Hello.
Bisleri bottle.
So give me a bottle of Bisleri. You don't say give me a bottle of water, right? So this is nothing but a mark, trademark. You know, mineral water means Bisleri water. Similarly, if somebody wants to go buy paste, which kind of paste? Toothpaste you will buy? Colgate. Somebody will say, go and buy. Similarly, if you want to buy shoes from, then you go to Tata. Then similarly, if you want to buy milk, salt, from which company you are going to buy? Like you are having a mind in notion. Shoes from Bata, then salt from Tata. So these are nothing but these trademarks. Trademarks means this. In short, you understand that these things are the marks or indicators which indicate that the product is made by this company, and this product has this kind of properties, or this kind of particular taste, or particularly this kind of quality. Therefore, that product has international recognition or recognition. So wherever if you go by, if you go by buying something like paste or some other thing, so you have a particular notion in mind that water means Bisleri, Bisleri means water. So that kind of things are nothing but the industrial trademark. Since that creates a market for the buyers or customers, so this is nothing but the company's goodwill in market, right? So this is nothing but the trademark. Similarly, we have service marks. You come across these kind of things on all the product which you use daily. So that may be a word mark, symbol mark, collective mark, certification mark. Then there are insurance sectors or banking sectors. All these are nothing but the signs and symbols which are applied on articles of trade which indicate that the product is from the same company. For example, if you see this mark, or if you see M, what is that M indicating? Can anybody tell me what is that M indicating here?
McDonald's.
So this is nothing but the trademarks. So in simple words, you understand that trademarks are the marks which are having international or recognition in state or a district or in a country, nation, and that has monopoly over the other products, because people if you have the choice of buying Bisleri water with Bisleri and you are having Aquafina, mostly people will prefer the Bisleri. Similarly, this kind of things are there. So these are nothing but the trademarks, and service marks relates to services. Services means Tata Sky, all these kind of banking sector, insurance sectors. These are nothing but the service providing companies, and therefore they are the service marks which are registered. Okay. Now after that, see, you come across all these kind of words. These are nothing but the trademarks which are used in trade to commercialize the product, and they have the market value. Understand that this much thing is sufficient for you to understand that what is trademark, what is copyright. Then there are geographical indicators. Now you know what is famous in Solapur.
Pomegranate.
Pomegranate is there. That is one good thing that is now registered as. But another important thing is there of Solapuri chadar, right?
Yes.
So whenever somebody goes to Solapur, what kind of things are said? Are go and buy some 2 chadars for me. Okay. These are nothing but then if you come to Nagpur, what is famous in Nagpur?
Orange.
Oranges. Then mangoes from Konkan, Ratnagiri, Hapus mangoes. Then Bikaneri Bhujia, all these kind of things which are particularly famous in that area. They say grapes from Nasik. These are because of the quality and because of the soil and because of the climatic features. These products are grown and manufactured there, and they have some value. So when these products are marketed or sent outside, now if you are given a choice that there is a chadar made from Mumbai and there is a chadar made from Solapur, then one person will feel which things to buy. Generally, he will prefer Solapur chadar because that is the thing which is already known and which is famous there. Similarly, that means geographical indication is nothing but a sign used on goods that have a specific geographical origin and possesses a quality or reputation that is slowly due to the place of origin. What is that place of origin? From where only this product? Nagpur Santri is Santri. Because the climatic features and the products and origin indicates that this product will have particular taste or particular flavor. So these kind of goods also enjoy advantage over the competing goods slowly because of their geographical origin. Thus, this becomes a kind of IP and is protected. So a group of farmers or group of cultivators come across and file an applications under geographical indications. For filing these, now one of my friends said pomegranate. Recently, pomegranate also has got a GI registration. So that is also registered. Now, whenever it comes to anybody's knowledge that there are pomegranates available from Solapur, many people will go and buy because they are having the climatic age or the procedure parameter of the qualities or reputation because of the place of origin. So this is nothing but the geographical indicator. Then industrial design. Now industrial design is again one important intellectual property. It is nothing but the ornamental or aesthetic aspect of an article. It may be in the form of 3-dimensional or a shape, circle, or 2-dimensional such as pattern, line, or this. Now these things are, you come across many kind of designs, right? You go for handicapped watches, mobile phones, every day you see all kind of changes are there in the shapes and size of the products, right? You see many cars are coming with different shape, particular car has particular feature, then water bottle, then many things like every day. Now if you see biscuits, simple example, biscuits are of square, rectangular, sphere, heart shape, many kind of things are biscuits are available. These are nothing but the industrial and because of this one person feels that I want to buy this product. Similarly, designs of mobile, some other different design is there, then pattern of watches, mobile phones, then laptops, then the different types of television, all these nothing, chairs, bottles, everywhere you come across many. You see these are the bottles. These are bottles made up of uh, these are bottles, but they are of different shapes and they lure the customer to buy. Similarly, mobile phones. See, many mobiles are there. Different shapes are there, and particularly that lures the person to buy that thing. For example, these are the chairs. These are the bum chairs. In which movie this was seen?
Three Idiots.
Three Idiots. So these are nothing but the chairs which lured all. After these movies, after the release of this design, so many schools, small nurseries or all the gardens started buying this kind of product. So this was having a luring effect on the customer. This is nothing but this is the chair for use for sitting purposes. But then this attracts the customer to buy because the students or children like this kind of thing. Then similarly chair. Then similarly, see, you get a water milk pouches. Then different kind of packagings are there. These are nothing but the industrial designs which have commercial value. Mind you, there are many Coca-Cola. Now, if you see this kind of symbol, or if you see this kind of shape of bottle, that you clearly indicate that this is the Coca-Cola bottle. So these are nothing but the industrial designs. So which are registered on the, and every day you come across different patterns on clothes, saris, on handicap material, handicrafts material, many things, everywhere you come across new kind of jewelry. Then these are nothing but the different shapes and sizes of cars coming to lure the customer. This is nothing but the ornamental or aesthetic approach of the seller who tries to lure the customer by seeing this kind of product. One feels like, oh, I should buy this kind of bicycle, or I should buy this kind of milk containers, or I should buy this kind of chair. There are many things which can be of aesthetic approach. So these are nothing but the industrial designs. Then we come across the important topic, that is patents. What is patent? Have anybody heard or have anybody filed any application for patent, or have you heard about this word? Okay.
Registration.
Okay. Now patents, first of all, understand, my dear friends, patent is now the topic of our presentation today. So we will go and discuss this in very detail. Now, what is patent? First of all, can you tell me who discovered India? Can anybody tell me?
Vasco da Gama.
Vasco da Gama. Then who discovered America?
Amerigo Vespucci.
Christopher Columbus, right? Hello.
Yes, sir.
No, sir, it was Amerigo Vespucci.
No, it's Christopher Columbus. You see who discovered America. Okay. Then apart from that thing, now who discovered watch, or who discovered mobile phone? Was it discovered?
Yes. No, invented.
It was invented, right? So mind you, my dear friends, please take a note of this thing. This is very important. This is one thumb rule and one basic requirement. So while coming for patent, you should understand, patents are granted only for inventions, right? Patents are granted for inventions and not for discovery. Was mobile phone lying anywhere? Just like India was lying in somebody visited Calicut and he found that, Vasco da Gama found that India was in existence there, or something which was naturally existence in the environment, and somebody found it. That is the discovery. But invention, when we talk of invention is the result of human intervention. Human intervention means, was the watch lying anywhere? Was the mobile phone or television lying anywhere? Was the fan lying anywhere? No, they were invented by humans, by their inventive skills, right? So this is nothing but the patents are granted for inventions. So mind you, keep in mind that while filing an application, you should understand that you should file an application for patent only for invention, and how that invention should be, that we will discuss in the latter part. But right now, just understand, patent is an exclusive monopoly right granted by government of India or government of that country, which is exclusive and monopoly right. Exclusive and monopoly right means only the one person's right. The person who has invented that will get the right. Now, can anybody tell me what is patent called in Hindi or Marathi? Can anybody tell me? Many times you use this word patent. अरे इसको patent दे देंगे, इसका dialogue patented है, इसका patented book है. All these things you are talking. Many times you talk. But can anybody tell me what is this patented? What is that?
Ekaswa.
Ekasva. So patent is known as Ekasva. Ekasva means Ekka Adhikar. Ekka Adhikar means only one person's right. So basically understand that patents are related to invention. First of all, while filing a patent, you should understand that you should bring out an invention. It should not be a discovery. Then it is an exclusive monopoly right granted by inventor to the by the government to use the patented invention for a limited period of 20 years. So what happens after 20 years? After 20 years, the patent lapses and the invention is free to be used by public. That is why you are coming across many televisions or many mobile phones or fan, watches, everything, because the monopoly is over. That is why you are getting the thing which was costing around 10,000 rupees now is costing 500 rupees or 700 rupees. It's because of the vitality of the patent or the validity of the patent is over. These are the invention which are available publicly. So in just short understand, patents are granted for invention. It's exclusive monopoly right by government for a period of 20 years, thus preventing others from making, using, importing or selling in exchange of full disclosure of his invention. Now in exchange of full disclosure of his invention means the whatever invention you invent, you give it to government, and government in exchange of that gives you right, because that invention is having some useful thing. Now if you come across remdesivir, now in this pandemic you might be hearing this word remdesivir, right? So remdesivir was is patented by Gilead Pharma. Now this patent is granted and therefore he is enjoying full monopoly. So this kind of things is a blockbuster invention. So these kind of things are there in the full disclosure. Now what he has done, he has given licenses, he has assigned that rights to some other companies. Therefore, almost 6 licenses are being granted in India, and therefore we can use that or you can get that. Otherwise, this patented invention is very costly. Remdesivir is costing 24 to 25,000 rupees medicine. But then because of this licensing, it is feasible that you get this medicine at very cheaper rate, 4,500 rupees, because Cipla and all these companies have taken cross licensing with them. So understand that patented should be for invention, it is for 20 years and it is in exchange for the disclosure. Now, what is the basic requirement that we will see in the later part? Then there is, you come across this kind of circuits. Where you see this kind of circuits?
That is the schematic diagram of any layout of any organization, any institute.
This is this is the motherboard of any computer or mobile phone. You when you open the mobile phone or when you open the computer or any other television set, you see this kind of circuits are there. These are nothing but the integrated circuits. They are again a form of intellectual property which is being registered. Just for your knowledge, you update yourself that there are these kind of motherboards are also registered under the Integrated Topography and Integrated Circuits Act. So then undisclosed information, that is trade secret. Now you drink Coca-Cola, right? You drink Coca-Cola, but then the taste of Coca-Cola is the same as that is of the 100 years. Even if you some people who have drank this Coca-Cola 100 years, the same taste is here because they have kept the formula as a trade secret. So this is again one sort of intellectual property which is known as trade secrets or undisclosed information. Again, this is protected. So this then there is you come across different kind of plant varieties, like you come across different kind of capsicum. Earlier you used to get only green capsicum, now you come across red, yellow, or some other different sort of capsicums are there. Then you come across different kind of colors of roses. There are black roses now. Earlier we used to have only one sort of there. Now there are yellow, white, red. Many sort of roses are available. What are these? These are nothing but the tissue culture made in the farming or by the farmers or the agriculture researcher, because of which they develop every day, come across new kind of plant varieties or these varieties. So they are again registered under the Plant Varieties and Plant Breeders Right Act. Okay. So this is nothing but the now see, briefly to summarize that, we have seen there are different kinds of intellectual property rights. They are patents, trademarks, designs, geographical indications, copyright, and plant protection. Now I suppose all these domains you are at least clear of what kind of thing is registered under patents, what kind of thing is registered under trademark, what kind of things is registered under designs, and so. So is that clear?
Yes, sir.
Anybody has any doubt? Okay. So these intellectual properties are these are protected under the Indian government has formed different kind of acts under which these rights are protected. And mind you, now patent term is for 20 years and registration is compulsory. Means you only have to get the patent and then only you will get the monopoly right. Whereas trademark is optional. You can establish the fact that I was using this thing, and after that also you can register. So that is renewable. But after 20 years, patent is lapsed. Then they design is again for 10 years and it's renewable by 5 years. Then geographical indication, its registration is compulsory. It's for 10 years and it's renewable forever. Then copyright, again, it's protected under the Copyright Act 1957. Optional lifetime of author, that is plus 60 years. So whenever the lifetime of author, it is there, but after the death of author also plus 60 years, it is in existence. Then plant protection, again, that is compulsory, which is for 15 to 18 years. So mind you, these things are clear.
Yes, sir.
Okay, these things are clear now. Okay, now just a minute. Now we will move to another part of the topic or discussions. Now I suppose all this intellectual property and different kind of intellectual properties are taken in record with you, right? Now we will go to another or the today's topic, that is patents. Now as I told you earlier that patents are for invention, it's for monopoly right, and then it is granted for 20 years, and then you have the power to use or prevent others from making, selling, importing, or in exchange of full disclosure of his invention. After the 20 years period is over, this invention falls in public domain and public is freely to use it. Now the question comes, what are the things? As I told you, there should be invention, right? Now what is that invention? How that invention is to be how the patent offices work. Now we are working in the patent offices. Now what once you file an invention, what we see, first of all, the invention should have, these are the thumb rule. Please keep in mind that for basic things for requirement of patents are, there should be an invention, it should have novelty in the sense it should be new one, it should not be copied of somebody, it should not be a copy of some other person. So there should be invention, but that invention should be new, there should be novelty. Then another part is there should be inventive step. That what is inventive step? Step means there was something in existence for which you add something, technical advancement is there, or some economic significance you have given to that invention, that forms the inventive step. And then another is industrial applicability. Industrial applicability is a very important parameter, in the sense you should not block the technology. Since patent is granted for as a monopoly right for 20 years, one person should not take the patent into granted as consideration, and he should not allow he should not stop producing anything. So you should be able to make multiple numbers of uh, uh, copies of that invention. For example, if you are making a television, then you should be able to produce in n numbers. It should not be restricted to 5 or 10 or any x number. It should be able to satisfy the public need, and at that too at the reasonable requirement and reasonable price. So mind you, there should be novelty, there should be inventive step, and there should be industrial applicability. These are the basic things which we look into an invention before granting a patent, right? Then who can file a patent application? Now question comes, who can file? Any person can file, either single or jointly with any other person can file an invention. Then who is this person? He should be the true and first inventor can file. The person who has prepared the invention can file. Then his assignee. For example, you are studying in this college, Shivtare College, and suppose there is a contact clause in which it is said that you are provided with laboratory materials, raw materials, manpower, everything is being provided by the college. So college forms a contract with you that whatever intellectual property right, mind you, wherever you will start going and work in industry, you will start working in the any research organization or any government functionaries or any multinational company, they have this clause in their service portfolio that all the property resulting during the tenure of this work will be the property of the organization, company, college, university, or any other research cell. Okay, so that means the assignee. Now if you are producing some invention, if you are making some invention, that invention will be the, now you will be bound by the contract of your college, saying that whatever invention produced in this tenure or in these premises will be the property of the college. So mind you, you are not, so here mostly the money will be spent by the company or the college. So that person also can file, then the legal assignee of that person can also find that application. Okay, now where to file? Now we have 4 jurisdictions. We have 4 jurisdictions. Patent office are located in 4 parts of the in India, wherein we have western, eastern, north, and south zone. As far as Patent Office Mumbai is concerned, where we are working, the territorial jurisdiction falls under the state of Maharashtra, Gujarat, Chhattisgarh, Madhya Pradesh, Goa, Diu, Daman, Dadra, and Nagar Haveli. So all these states falling in this category should file application in Patent Office Mumbai. Similarly, the Chennai, the states of Andhra Pradesh, Kerala, and all these people can go and file application in Chennai. Have to file means they have the place or address for correspondence in that location. The applications will be registered in that kind of. So patent office is in Delhi, and then we have another patent office in Calcutta. So these are the 4 patent offices, and accordingly jurisdiction wise we come across these offices and we do the registration work, right? Is that clear? Any doubts?
Yes,
Please,
sir.
mind you, please stop me if you are not getting. Okay, now any person can file with the research organization or any other with any joint inventors can file, any company can file, any person, any legal entity can file patent application. I told you the jurisdiction under which this can be filed. We have particular website which says that ipindia.nic.in. So here we get all the details of what kind of things, what kind of fees is there, what kind of structures, what kind of forms, how the procedure is. These things you can take from this website. Okay, and then apart from that, now there are types of patent applications. Now what is patent application, right? Now you have decided, you as a scientist or you as an inventor have come across some good idea. Okay, I will produce something inventive. Now leave apart from other intellectual properties. Now we are focusing on patents. When we are focusing on patents, we are focusing on inventions. And what is invention? Invention means any product or process, any new product or process having novelty, industrial applicability, and inventive step. This is nothing but you have to take in mind. Now, for example, one of my friend thinks he can prepare a blockbuster medicine or blockbuster molecule. I suppose there are many biotechnology people. So I find some of the good inventors are having good track of knowledge in their field. Suppose he's having one thing in idea, and now he wants to produce any medicine for just for example this pandemic in this COVID-19. So if you have any idea, or if you come across one thing, okay, I can stop COVID by doing all these things, or I can stop COVID by making this kind of product. So once that idea strikes his mind, now Patil sir rightly said, publish or perish, right? But the concept is old now. Publish or perish is not the thing now. It's a file, publish, and then perish. Okay. So first of all, you should file. We come across many scientists, many good IIT students, many good students, many research professors. They don't know the patents P, and they come and what they do is in the sake of publishing their article or publishing their research paper, they just publish the paper, and once the paper is published or it comes in market, it loses its novelty. And then after someone comes and tells him, Kyare, you should have filed patent for this application. Mind you, my dear friend, we are helpless. We are helpless. Even though your patent is good, your invention is blockbuster, your invention is creating miracles, but it's of no use because you will lose the novelty. Once you lose the novelty, you will not get patent anywhere. Anywhere you cannot get. Okay. So this thing you should keep in mind. So once you get an idea, you reduce it on paper, come to patent office, file up ordinary application. Now I will come across what kind of applications we are. So when we are talking of ordinary application. Now application is ordinary in the sense it is a provisional or it should be with complete specification. Specification is the document in which whatever invention you make is properly disclosed in the format as disclosed under section 10 of the Patent Act. Now I will come across this thing. So first of all, understand that once you get an idea, you reduce it on paper and file a provisional application. Mind you, what is the advantage of filing this provisional application? You get 12 months time. Okay? 12 months time to file your complete specification. So ordinary application can be filed with provisional specification or application with complete specification. Now, what is that complete and what is provisional? So I told you, once you get the idea, you are going to prepare a medicine for COVID-19. Now, and by what idea is that you have to reduce it on writing. So that simply idea with writing, you can file a provisional specification, giving the things that we will be doing this kind of research. We will be trying using these raw materials. We will be using this precursor. We will be using this kind, and we will get this product. So that is nothing but your idea, and you have reduced it on paper, and you have filed a provisional specification. So, or what one thing you can do is you can start working on that invention. You can start working on that invention. So you can work with the invention and complete the invention. You prepare that drug or prepare that medicine and then file a complete specification. But one important thing is in the patent law is the thumb rule of patent law is first to serve, first to file. You keep in mind the person who comes and files his invention first to patent office or discloses invention to first patent office, the date is the registered date, and that registered date is known as priority date. So mind you, once you block the priority date, all the documents or all the publications which are published after this date will not be taken into consideration while dealing with novelty, inventive step, or industrial applicability. So it becomes a very important thing that once you get the idea, once you get the notion of how to prepare that drug or how to prepare that process of the product, that kind of thing, you first file a provisional application and then you can make publication, and then you are free, then your right is protected. Nobody can come and say that this was my idea and this thing, because you are the person first to file, and you have filed that invention properly in the proper format. So that invention is being disclosed to government on the date, and that date is known as the priority date. So it's very important that you first file your provisional specification, and then you get 12 months time. So what is the advantage of filing provisional specification? You get 12 months time to develop your invention. So I told you, once you got the idea of preparing that drug, now what you can do, you start working on that. So you get 12 months time. What in these 12 months, what person gets, what advantages the person gets is that he can go and collect some financiers. He can discuss this idea with some companies or support persons who can help him financially, or then he can study the product feasibility of the compound or product feasibility of that product, whether it will have any international market, or what kind of advantages is this, or whether this kind of research is done by someone else. So so accordingly he can plan to proceed. So this is nothing but a provisional specification. Complete specification is that you have to file after 12 months, within 12 months. So once you get the idea, you prepare the drug and you file the application. So that is nothing with the complete specification. I told you the advantages. So it's always feasible to file a provisional specification, reproduce your idea in the form of a text, and then file the application and claim the priority date. So this is one thing that you keep in mind while filing the patent application. Then I told you, you can file a complete specification directly by filing complete. Once you complete your invention is ready, you can file the application. Then there is convention application. See, mind you, government of India has signed many conventions, that is Paris Convention, Bern Convention. Many conventions have been signed. So according to Paris Convention, what happens, and any application on the conventional countries which are part of this convention give a specific right to all these nations who are conventional countries. Like for example, in US is a convention country. You can file an application in US and come within 12 months to file the application in India also. So you get the idea, you get the conventional status. So conventional application is the application which originates outside India, but India being the conventional country, you can file to its application from in 12 months in convention countries, that is India. So this is conventional application. Then PCT international application. What is PCT? Anybody heard about this word? Anybody heard? Okay. Patent Cooperation Treaty. So it's nothing but a treaty. Now earlier what used to happen, there were many inventors. Now there were single inventors who are not having knowledge of laws or patent laws or any other country's law. Now he finds that his patent is useful for not only India but in many other foreign countries also. So what he used to get, he used to file a separate application in Europe. He used to file a separate application in China, in Korea, or US, or Germany, or in any other developing countries, or any other country. So what was the issue? Mind you, patent is a territorial right. Territorial right means restricted to the jurisdiction in which now Patent Act India is restricted to India only. So you get the right only, you get the protection only in the borders of India only, right? But when you want protection in other countries also, for example, if you want, you know that your product is having market in China, Korea, South Africa, or many other countries, Europe, Germany, many other countries. So you wanted to file, then there were a lot of hurdles, lot of problems were there, like translation issue, fees, legal lawyers, attorneys. So to avoid all these things, a common platform was signed, that is the Patent Cooperation Treaty was signed by, now almost 188 countries are signatories of the this PCT treaty. Now this is administered by WIPO, that is World Intellectual Property Organization. So when you file the PCT international application, a single application in English language serves the purpose. Plus, you get the benefit of fees filing. You do not require any translation to be made. Once you make an application, you can select that applications from the 188 countries and proceed in the national phase application stage. So this is PCT national phase. So international application is a single platform on which you can register your patent in many countries, right? Apart from India, you can register in many other countries which are signatories of the cooperation treaty. Then there is national phase. Once you enter the PCT national phase, you international application, then you get a search report. That is search report by WIPO, and then also again a preliminary report which gives a rough idea of what the invention will be, how the invention will, whether it is having novelty or whether it is having industrial applicability or either it is having inventive steps. So you gives a rough idea. So then if you want to proceed, then you can proceed. Otherwise, you can stop at that stage. But then after, if you get a good idea or if your invention is good and if you get positive reply from PCT, WIPO, then you can file a national phase application in that country. Then again, I told you there is one patent of addition invention. Now what happens? You file a patent application, you get patent for that. Now, for example, produce penicillin by rupees 5 in 10 rupees per mg. But if you again develop that, again go in further research with that patent, and if you come across with 2 rupees or you are able to make that invention with less than that money, or you can make some development in that earlier patent which is in economic as well as beneficial, that can be considered as patent of addition. Then there is another application, that is the application which is known as divisional application. What happens in divisional application? What happens in divisional application? Divisional application is nothing but see, I told you a complete specification. So again, another thumb rule of patent law is that you will get only one patent for one invention. So if it so happens that in your complete specification you have got 2-3 inventions in it, and the controller is of the opinion that there are more than 1 or 2 inventions, so what to do with that other invention? So to protect that invention, because you have filed that invention on the same date, to protect the priority of that invention, you can file a divisional application. So these are the 7 types of applications which we are presently registering in India. Then there is startup and there is the expedited examination that we will come across. So now what is the necessary things that under stain that is required to be disclosed in the complete specification? So what it should be describing the essential features of the invention. Then you should give details of manner of performing the invention. Then it should restrict the claims to the boundaries on which he wants the protection. So these are the things: summary, then abstract, claims. All these things form the part of specification. So these are the things which are required to be filed while submitting. Now apart from that we have some procedure. Now what are the documents? Now I told you, first you make your invention, whether you are filing a provisional or whether you are filing a complete specification, that you decide. Then again, if you want to file a PCT, if you want to file PCT application or convention application, again that you decide. So after deciding that work is over, after finishing your specification writing, what else procedure is required? Now you have to disclose. A form 1 is there in which all the disclosures are required to be made, like who is the applicant, who is the inventor, who is the assignee, where is the address for correspondence, what is the title of invention. All that is been required in the form 1. Then there is a form 2 that is known as complete or provisional specification. I told you provisional specification is a rough idea. It need not include claims, but complete specification is a complete part. So you need to disclose invention as well as the claims for which you want a protection. Then there is again statement and undertaking on form 3, which says that you can, if you are filing the application in WIPO or PCT, then you get an international search report and you prosecute your application in other countries also. So what is that status of that application is to be disclosed on form 3. Then abstract is there. Again, the fee structure, I told you fee structure is there in our full-fledged website. You can see what kind of fees you are required, in what context you are filing, whether you are filing as a natural person or for a small entity, or you are for filing it with a company or a research organization. That you can get fair structure on ipindia.nic.in. And then power of attorney, you filed through patent agent. So you have to file form 26 if you are filing. See, now you are science students, you want all these things. If you can prepare your invention well within by your understanding, then it's okay. But if you are not able to produce anything, or if you are not able to reduce it in writing, so you can take the help of patent agents. Mind you, there are many patent agents registered under our Patent Act, and these patent agents work as a attorneys, and they prosecute in front of us. So whenever we give them whenever we any action is filed through them, the applicant need not do anything. The attorneys or the patent agents will do into their part. But it is not advisable. It is not recommended that you should file the application through a patent agent or patent attorney. You can yourself file a patent invention, because patent invention is your baby. You have invented that thing. So you are the person who knows everything about your A to Z about your invention. So you only just give it to write in a writing draft to him, and he just drafts accordingly. But and not necessarily you should file the application with the attorney. You can file. You are the creator of your intellectual property, so you can always write what you are done in your specification, right? Then again, apart from this, then there is one form 18 which says that you should file an application for request for examination. Once you file the application for request for examination, then your examination is carried out. Now these are the forms which just roughly I'm sharing. These are the forms which are readily available on our website. You can just fill the details. Just for example, you can give here the details of the like name, address, title of invention, agent or not, then address for correspondence. If you are filing all, whether you are filing in national application, ordinary application, PCT application, or all that details are there. One can read and easily write it out. You are filing through agent or not. So these are the forms. Then form 2, again I told you, provisional specification only describes the invention, but for complete, it should describe the invention, the manner in which it should be performed, and the claim part. So again, form 2 is of this kind of thing. You should click here whether you are filing provisional or complete. That depends. That is again the procedural part. If you are filing application through PCT, you can disclose here right now yes or no, whatever. If you are not filing through that, that is the thing. Then form 18 is there, form 26 is there, form 5 is there. Now form 5 is there because what happens now, I told you, if you get an idea and if you want to produce that invention or if you want to start working on that, but you feel like you single person, as a single person, cannot do this kind of work. You will need some help of some assistant or some friend or some other subordinate who can work with you, or some research guide or some other person who can help you in this invention. So you can add his name also by adding the form 5, right? So this is for that purpose. Then again, after filing the patent application, there is a procedure known as you have to wait for 18 months. After 18 months, this application is published. Published up till 18 months, this is in cold storage with Government of India, kept as a secret. It will not disclose to anybody. But after 18 months, it will be published. But and afterwards, the prosecution start. So to avoid that kind of thing, also we have made for provision that from filing form 9, you can make a request for, instead of waiting for 18 months, you can immediately ask them to publish the invention and come in queue by filing request. So form 9 is you can strategically move your application very fast by filing form 9 and get it published instead of waiting for the traditional period cycle of 18 months. You can immediately, once you file, within 1 month this application is published, and once this application is published, it comes in queue for request, and it is in the examination stage. So once you file form 18 also at this stage, you can start the procedure becomes very fast. So by traditional route, it takes around 2 to 3 years, but within this route, almost within 1 year, the patent gets granted. That depends again on your prosecution, how you prosecute the application, right? Then power of attorney is there. So generally, what are the things that are should be contained in the complete specification? Title of invention, field of invention, background of invention, object of invention, statement of invention, detailed description, and claims. And mind you, abstract, and if drawings are required. So again, I told you there should be a request to be made on form 18. That request has to be filed by a request form, has to be filed for examination. If no request is filed, that will be treated as withdrawn. So in simple word, now understand the procedure. Once you file a patent application by preparing complete specification or provisional, then I told you, you can get it published by filing form 99 by early publication, or wait for publication for 18 months. then it comes for request for examination. Now at this stage, what happens? The examiners, we have a dedicated team of examiners who are specialized in the field of the invention. For example, we have many biotech engineers, we have many biotech chemists, then we have electrical engineers, we have mechanical engineers. So all these persons, what they do is they are, once the invention is of belonging to that field, for example, the invention is related with chemistry or pharmaceutical or microbiology or any biotechnology, that is handed over to the biotechnology specialized examiners who conduct the search for what search. Now whether that invention is new, whether that invention is having industrial applicability, or whether that invention is having inventive step. So once he raises some objections. He raises the objection, and in that process is known as the examination. Once the examination is conducted, the gist of objections are communicated to the applicant or the inventor, whoever the person is the applicant, right? So once the exam, after filing your specification, the app specification goes to the technical person who is the subject matter of specification belongs to. If it is related with mechanical engineering, it will go to some mechanical engineer. The mechanical engineer will conduct a thorough search on these grounds. I told you, for getting patent, that should be new invention, there should be novelty, there should be inventive step, there should be industrial applicability. So once that thing is going on, after that examination, he raises the objection. A gist of objection is communicated to the controller. Now what we do is, once this gist of objection is conveyed or communicated to us, what we send a report to the applicant or the inventor. That is known as patent first examination report. So that is known as the first examination report. After this examination report is received by the applicant or the inventor, he has the time to file, or he has the time to address the objections raised by the examiner in the examination report by stating that, sir, what you have found out, what documents you have found out are not the documents which are relevant to my invention. So you can always cross that thing, and within 6 months you have to file the reply to the patent office, back to the patent office, stating that you are not agreeing with the controller's objection or examiner's objection. So we are having this kind of option, or we are having this kind of opinion. So once that reply is submitted, again that file goes to the examiner. He then looks into your report in detail, and if he finds if it is okay, then he asks us to proceed with the grant of patent certificate or patent. But if he is not agreed or he is not happy with the response, then he again raises his objections. These objections are again communicated to the applicant or the inventors. These inventors, again, once these are communicated to the controller offers a hearing, personal hearing. Hearing in the sense you can address the thing. Now, the controller, while seeing the objections of the examiner as well as the parties, controller summon you for hearing. You have to appear for hearing. That may be of video conferencing or that may be personal hearing. That depends on the circumstances. Presently, we are dealing with the video conferencing hearings. So once that things are there, what you can do is, once that hearing is over, you convince the controller that this is the thing, this is our invention, and what documents or what citations are raised are irrelevant and are no use. Therefore, you proceed with the grant. So once after the hearing, the controller hears both the parties, the examiner as well as the applicant or the inventor or his attorney, and then he issues a order whether he is granting the invention or whether he is refusing the invention with a reasoned order. So this is the scheme of examination. In the meantime, there are two steps. There is one pre-grant opposition and then there is a post-grant opposition. What is pre-grant opposition? What is pre-grant opposition? So pre-grant opposition is nothing but the opposition which is before the grant. So any person can come and say, sir, this is the invention, you should not grant this invention because it is in my knowledge. any general public can come and say, this is the thing which is readily available in market, and why you are giving patent to him? So he can cross that invention by filing a pre-grant opposition. And another part, even if this pre-grant opposition doesn't come, then if your application is proceeded with the grant and it is published, the patent is granted, still after that also one year time is there within which you can oppose the patent. Now mind you, here for opposing the patent, one thing is very important, that here the person should have locus standi. The person should be person interested, not any person like 25(1). It's saying that any person can file opposition, but in post grant you cannot do that kind of thing. It should be a person interested who can file the opposition in the after grant of patent. So this is the scheme of examinations. Once this is over, the patent is granted. This kind of certificate is given by government, and it's valid from the date of filing of your application for 20 years. So it is an exclusive temporary exclusive right which is being granted to inventors for publishing his invention. So I suppose we are beyond the time again. So I suppose this is the clear, or should I take 10 minutes more? Hello.
Yes, sir.
Naidu madam, can I get some 10 minutes more?
Sure, sir. No problem.
No problem. Okay. Because we will be leaving behind some important thing which I would like to again point out.
Yes, sir. Please.
So I'll just take 5-10 minutes.
Yes.
Okay. The procedure, I suppose, is clear.
Yes,
Hello?
sir.
Procedure is clear. So what kind of process is there? You just have a rough idea. Okay. What kind of things are required in specification, all types of application, what kind of things are there. Apart from that, I told you there are patents are granted for inventions, and that invention should be new, novel, and there should be inventive step as well as industrial applicability. Apart from that things, there is one part in which we cannot consider this invention as a inventions. What these are quoted under section 3 and section 4 of the Patents Act. It says that, for example, if you say frivolous invention, what is frivolous invention? Frivolous inventions are inventions which are contrary to well-established natural law. For example, if you say that machine gives more than 100% performance, that kind of thing is that kind of things becomes frivolous material. So for that, we cannot be given patent to that kind of a invention. For example, any perpetual machine. So these kind of frivolous inventions are not granted. Then section 3B, it says the primary or intended use or commercial exploitation. Mind you, it says that primary or intended use or commercial exploitation would be contrary to public order or morality, or which causes serious prejudice to human, animal, flower, plant life, or health, or to the environment. For example, if you are preparing a gambling device, a device for housebreaking, or any biological warfare material, now we are coming across, we don't know what is the status now. Somebody's are saying, many people are saying, many countries are saying, many big authorities are saying that coronavirus is created as a by China and Wuhan and all that thing, but we don't know the reliability of that thing. But this kind of materials, if you are trying to prepare, this kind of inventions will not be granted patent. For you, if you are making a house-breaking device, and how that is against the morality, against the principle, then onco mouse case, embryonic stem cell, all these kind of things are not patentable. Then again, then 3C says the mere discovery. Discovery, I told you, somebody will come and say, I have discovered an elephant, or I have discovered something which is in existence, some discovery of micro. So mind you, whenever somebody comes across a discovery of freely substance occurring in nature, any natural gas or mineral, or which is things which is lying in the nature and you are just bringing it out, that will not be treated as invention. So discoveries are again not patentable under the Patents Act. then 3D. Now this is very important in terms of derivatives or salts, esters, or polymers. Now what is the mere discovery of a new use of a known substance which does not result in enhancement of known efficacy of that substance. So mind you, the derivatives or of the derivatives or the new use or the new known process use are not patentable under the thing. For example, now see mere new use of an aspirin in heart ailments. So if you are aspirin is known for a painkiller, or aspirin is known for as for reducing analgesic. But if somebody says that I am using analgesic for heart ailments, then the use will not be patented. For example, new use of any neem, we know any use of neem, that again will not be patented. Then again, substance which is obtained by mere admixture. For example, paracetamol and brufen. You know, paracetamol and brufen, there's one tablet known as combiflam, right? But it's not an invention because it is a mixture. You know that paracetamol is known as antipyretic, whereas brufen is known as analgesic. So both, if you take the combination of it, it will definitely yield the same thing, the same application, the same use of these drugs will be used in painkiller as a painkiller only. So that kind of things, so these are not patentable. Then again, a mixture of sugar or some colorant in water to produce a soft drink, again it's a mere admixture. But if the mixture results in something new or something new, and that becomes a useful thing, then that kind of thing, like for example, paracetamol with brufen, a combination which is used as a antipyretic or brufen as a painkiller. But if you find any other thing that if it is useful in the, suppose for example, COVID-19 coronavirus pandemic, for coronavirus, again effective against coronavirus, then we can think of that, okay, this is a synergistic, it is giving some good results. So in that case, we consider that as a synergistic mixture, and therefore we don't treat it as a admixture, it is a novel invention. So then again, three, after then somebody comes with a, this is one important thing, when mere arrangement or rearrangement or duplication of known device, each functioning independently of one another in a known way. Now one person says, one person comes with an invention, a bucket fitted with a torch, and our umbrella with a fan. You see in many times there are some posts, or there are some common jugaad inventions, we call them. These kind of inventions are again also not patentable. For example, a clock and a radio in a single cabinet. Some whimsical inventions, you see some funny inventions, you can see them. That is just the mere arrangement or rearrangement of known devices having, because we know bucket is used to take water, as well as torch is to throw light. So known usage is there, nothing synergistic or nothing important thing is there. This is nothing but the mere arrangement, and therefore these kind of things are not treated as invention. Therefore they are also not patentable. 3G is also omitted. Then 3H, the method of agriculture, method of knowing new form or of, so that 3H is also not patentable. Method of agriculture, or because India being the farmer oriented country, many farmers are working, so many method of farming, that is not patentable. Only agriculture instruments, equipments are patentable. Okay. Then again, mind you, there is one important thing, that is 3I. You know that any process for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or treatment of human beings, or a similar treatment to animals, to reduce and render them free of disease, or to increase their economic value of that product. Now we are coming across these kind of examples right now. What happens if the method of treatment or method of medicinal, surgical, any, all these kind of patents are granted? Doctor will charge exorbitant amount. For example, now you are coming across medicines, or you are coming across COVID treatment. Now the government is having, so in this case, government having is say by saying that you should not charge this much amount. There are many hospitals who are charging exorbitant amount of money, but that may be not related with patent, but they are doing this kind of practices. So to avoid this kind of practices, Indian government is very strict. We will not grant any process for any for a method of surgical, or like a method of treating COVID, or method of treating conducting a bypass, or method of treating angiography. All these kind of medicines or all these kind of treatment, whether it may be medicinal, surgical, curative, prophylactic, means that like vaccination or diagnostic, therapeutic, all other these things are not patentable, because they are if they are useful for the treatment of human beings or animals, or they increase render them free of disease. So whenever this kind of inventions you are taking in mind, you should avoid this kind of invention, because any process for medicine, all these are not patentable subject matter. Then again, plant and animals in whole or any part thereof other than only microorganisms can be patented, provided that they are genetically modified. But plants and animals as a whole, they cannot be patented. Then 3K, again, computer program per se cannot be patented, or algorithms cannot be protected. They are protected under the copyright. Then again, 3L says that literary, dramatic, musical, or artistic work, or any aesthetic work, including cinematographic work or television production. This forms the matter of copyright, which we had earlier discussed. So these kind of inventions are again not granted patents. Then 3M, a mere scheme or rule or method of performing a mental act, or playing a method of playing a game. For example, your scheme for learning a language, a method for solving a crossword puzzle, all these kinds of things are mere scheme or rule. For example, Kaun Banega Crorepati, that kind of method of playing a game is not uh, granted any patent. Then again, method of teaching or learning, that also is not granted any method. Okay. Then presentation of information, any words, like one delivers a lecture, that lecture delivers by either by spoken words, visual display, symbols, diagram, that cannot be granted patent. Okay. Then topography of integrated circuits, I told you that is again granted under the topography and integrated circuit parts. Then traditional knowledge. So you have come across many inventions like neem, turmeric, basmati, all these are the inventions which are traditional knowledge. What happens during our ages, while working in kitchen, sometimes we cut our hand or cut by our fingers, and blood is started coming out. What is the general advice given by any senior citizen or old person, grandfather, grandmother? What they say? Just apply a pinch of haldi there. So that is nothing but the traditional knowledge. And mind you, you might be aware of all these case laws which has happened in US. The wound healing property of haldi was taken as patent. Then basmati was basmati was again taken as patent as tasmati in US. And you know, CSIR and all that has a lot of work to Professor Mashilkar had a lot of work to do, and then a lot of things which were traditionally known, because these are the things which are traditionally known in our knowledge. And somebody tried to get patent on that by filing a patent application in other country and US, and that too granted an application for haldi, neem, and basmati. So we have to file a long battle to get that patents revoked. So again, that traditional knowledge which is available in our Charak, Ayurveda, Unani, Siddha. In fact, you come across Ayush. After all this tragedy, Ayush ministry came. Ayush ministry is nothing but the Ayurveda, Unani, Siddha, and homeopathic, Ayurvedic. All these kind of medicines is nothing but the Ayush. Ayush itself indicates, Ayush means AY is indicating Ayurveda. U indicates Unani, S indicates Siddha, and H indicates homeopathic. All these medicines traditionally known, because we have prepared a traditional digital library in Ghaziabad, Delhi, which is having all the books which is having resources of Indians right from 16th century. Around 20,000 books have been digitized, and they are created in the form of the library, because we were not able to defend that kind of things, because once this kind of patents are granted, it becomes very difficult unless and until we have some citations, we have some proper documents established in our law or in our culture or in our traditional books. So these things are also not grantable patents. Then again, atomic energy related invention, that is section 4. That is, if they are harmful to our threat or security threat to government or India, then that kind of inventions are not granted, particularly to uranium, beryllium, thorium, and all these electromagnetic or radioactive substances. These kind of substances are again invention falling under, they are not patentable unless we get a clearance from Department of Atomic Energy, right? So these are the things which are uh, very important right now. I suppose I may be fast, or many of the things may not be clear, but it's a big process, right? Because we have covered many topics in these things, right from the intellectual property, then types of intellectual property, then we have taken some rough examples with related to copyright, geographical indication on all that, designs, and then we came across patents, what is patent, types of patent filing, then what are the procedure for filing a patent, and then what is the types of patent applications, and finally we came across under the exceptions under which patent cannot be granted. So these are the things which I wanted to point it out. So I suppose this much is enough for today. I suppose you got a rough idea or brief idea about what we want to say. So any doubts, anything else which is not understood? Hello?
Yes, sir.
Any questions?
Sir, I just have one question that came to me via a student, a
Yeah.
participant.
Yeah.
So are testing kits like
Kids
COVID
we are
testing?
not giving. Kids is not an invention.
Okay.
It is not an invention. So kids we are not giving.
Okay, sir.
Yes.
Sir, I have one query.
Yeah. Please go ahead.
Sir, if any medicine or any pharmaceutical medicine that is patented, and some original company producing or manufacturing medicine which having a price of around 10,000, but it is patented, but other generic company of the same API, they are manufacturing the same product and that price is about 500. Then I question is that it is the break of law of patent?
Yeah, definitely you cannot produce that thing unless and until you get a cross license or a cross licensing, or you assign the rights to somebody else. You cannot get that thing, na?
But it is generic medicine is the government authorized organization, no sir?
No, but
Because
let it
pure
be a government organization, but right is also given by government only, na?
okay.
See, there is a provision which says under section 84, that is compulsory license. So all these generic companies, what they have to do is they have to go to the company which is having the product or the patent on that product, and if they want to prepare any generic drug on that, they have to get a cross licensing. That I told you that Remdesivir, Gilead was having the patent. Gilead is having the patent, and therefore almost in India 6 companies approached, and all these 6 companies got license, though on their terms and conditions that they will not sell the medicines at this price, or they will give some royalty to the company which is giving that thing, or they will share the profit. That depends on the contract, or that depends on the assignments you make with the company who is having the license or who is having the patent on that, right?
Okay. Thank you, sir.
But if somebody is using it unauthorized, it will be infringement, and mind you, he will be in behind bars, and he will not be. He will have to pay a huge penalty.
Okay.
If it is proved in infringement in the court of law, if it is proved,
Okay.
then he will have to pay a lot of huge penalty. Even that what profits he has got, he has to give it back, all the bank accounts and all the uh, batches which have been lapsed and sold, or in the market, all
Yeah.
that accounting will be done, and everything will be taken away from him. So you
Okay.
cannot
Okay, sir.
use anybody's patent without his permission.
Okay, sir. Thank you.
Hello, sir.
Yes.
Sir, I have a question. Like each and every patent have some expiry date, right, sir?
Right.
So after that expiry, we can either use that information or I can modify that information according to my way. So is there any website or any department which shows us this kind of information that this patent is expiring, or Can I get this?
No, sir. As such, that data is not available. What you are saying is, but you come across these inventions. You can go by year wise. Suppose now it's 222, right? So the patents which were filed and granted in 2002 will be expiring into 2020. So you can get a list of patents that from our website or annual report. You can get that information which patents were granted in 2002, which will be expiring in 2020. 22. So that information, once that year of grant is with you, you can easily check on everything is public search. In public search is available.
Okay, sir. Thank you very much.
Thank you so much.
Any other questions?
So I think, sorry, we might have to take a pause now, and I'll ask the
Yeah.
participants to write to me so that I can forward the questions
Yes.
to you, if that is okay.
Yes. Thank you, friends. Thank you for patience hearing.
Thank you,
Thank
sir.
you.
Thank
Any
you.
doubts? Any doubts? You can mail me. You can say to talk to madam, and you can send mails to me. No problem. Okay.
Thank you so much, sir. It was an extremely comprehensive information regarding patents, and I'm sure people from all streams, whether it was arts, commerce, or science, all of them have been able to understand what this idea is, and hopefully all of us will go for patenting of some of the things that we're thinking.
But at least they will have the clarity that this kind of things are not registered under patents.
Yes, sir.
Things are not under patentable. Trademarks, all these they may be aware of. Now right now they might have got some idea about intellectual property. In future they may be working as business person.
Exactly.
They may trademarks may be useful for them. Then industrial designs may be any other sort of copyright. Some may be authors, some may be writers. So that may be useful for them also.
Yes, sir.
Okay.
Thank you so much, sir. Thank you.
Please. Thank you.
All right. Thank you, everyone, for listening to the talk. I would like to now move on to our second invited speaker, Dr. Rajiv Taggar. Sir, first of all, we apologize for the slight delay in the beginning. But can I, before we start his talk, can I please request our Professor Chakre, sir, to introduce Dr. Taggar for his talk.
Hello.
Yes, sir.
Okay. Thank you, ma'am, for giving me opportunity to introduce our today's second chief guest, that is Shri Raju Taggar Sirji. So, sir has completed his MSc in two different subjects. One is in the botany from Kurukshetra University, India, and MSc in plant genetics and comp improvements from John Innes Centers, University of East Anglia, UK. After that, the sir has completed his MPhil in two different subjects. Again, the MPhil in botany from Kurukshetra University and MPhil in crop genetics from the University of Reading, UK. So after that, sir has established one renowned institute in our India, that is Saika Biotech, a private company which is associated with the agricultural biotechnology. So, sir has a specialization in molecular breeding with an extensive training in various plant biotechnological techniques. Sir is associated with biotechnology in different seed industries over 20 years. Sir has a scientist in charge of molecular breeding activities and worked with some well-renowned institutes in India or organization which is working in the agriculture field, that is Bayer's Crop Science India, Krishidan Seeds India, International Crop Research Institute for Semi-Arid Trophics, that is ICRI SAT India, Greenworld Genetics Malaysia. So, sir and his team is currently working on the crop breedings by using molecular breeding technologies. So sir has established the molecular breeding laboratories and molecular breeding programs for the Bayer Crop Science, Greenworld Genetics. Sir has various renowned works. For that, the sir has nominated for the Commonwealth Scholarships of the UK. Sir has got National Talent Scholarships. Then sir is working in the plant biotechnology techniques. For that, he has got the professional techniques from Germany on DSE sponsored training course from Central Research Facility of Netherlands, ICRI, SAT, Hyderabad, India, John Innes Centers, National Institute of Agriculture Biotechnology, Biobotany from Cambridge, UK, University of Reading, UK, and University of Nottingham, Malaysia. So this is what just a brief introduction to our Tagar sir. So the actual work of Tagar sir will be explained by his thoughts. So I welcome to the sir for expressing his views on the different fields of the biotechnology. Sir, I welcome you.
Hello, thank you very much, Dr. Chakre. Is my voice audible?
Yes, sir.
Okay, sure. Okay, thanks a lot for the very kind introduction. I have to be very honest, and before I go into into starting with my presentation, I think I should share the screen first. Okay, is the screen visible?
Yes, sir, it is.
Okay, right. Okay, good afternoon, everybody, and thank you very much for a very kind introduction. And I have to be very honest in saying that, like Dr. Chakre has already said, I'm not from the IPR background. So I've been working in the area of plant biotechnology. And so that is the reason I'm going to be sharing my, basically I'll be sharing my views, how sharing my experiences about how IPR has impacted my work and the sort of issues that have cropped up on the way while I was undergoing my work as a scientist in biotechnology. So again, so obviously not be just the way Dr. Ajay Thakur has attempted this subject of IPR in a very comprehensive manner. I will be pretty primordial, pretty fundamental in addressing some of the issues because they've been already discussed. But then I will be touching more upon how the IPR impacts plant biotechnology. Since we have quite a diverse audience, including undergraduate students, postgraduate students, PhD scholars, and I could see from the interactions that there are some of the quite highly placed, much learned people in this area. So I'll try to be, to be honest, I shall be pretty, I'll be putting forth my my vision and experiences as a biotechnologist without going too deep into IPR and how I think my experiences as a biotechnologist can benefit the budding scientists, the biotechnologists or the biological scientists, the sort of things where I lack and where I feel most of the researchers and students in biological sciences suffer. I think those are the issues which need to be addressed. So in a way I'll be cataloging where what the things which I missed out and where the students can pick up. Right. I'll start with that. Like I said, I shall be focusing on IPR in agri-biotech. So since I have been working on the plant biotechnology, so my focus will be more on agri-biotechnologies. And rather than going into into technical details of IPR, I shall be discussing some of the case studies and personal observations as a biotech researcher, not as IPR expert. So obviously we can take up both the ways. I shall be talking a bit about how biotechnology can complement or can add to or aids IPR, but also how IPR aids the biotechnology. So we can take up the case studies in both the cases. And then IPR first aid of biotechnology. Now, quite a bit of what I'm going to say has been taken up by Dr. Thakur already. So I'll try not to dwell too much on those issues. But apart from that, let's see if you can Okay, now before I go into the IPR bit, I should, clearly define, state it that biotechnology is quite a diverse area. So anything that is, that is involved in the applications of living entities or life processes towards human or environmental good is, comes under the purview of biotechnology. So, and that basically means, a lot of things which could be in microbiology, plant sciences, or agriculture, or biotechnology, they all could pretty much fall under the purview of biotechnology. So for this talk, I shall be covering all these areas under the umbrella of biotechnology. Right. When we talk about the role of biotechnology, in IPR, my experience was, this was the work I did in ICRISAT, Hyderabad. I worked on maize DNA fingerprinting, and I was given a project on protecting the maize varieties of a private organization. And because of this, I went through some of the, so that is when I realized, so in this case, I worked on DNA fingerprinting in order for IPR, intellectual property rights protection. And so DNA fingerprinting is used for crop variety registration and legal protection, as also for protecting the proprietary hybrids, the varietal hybrids. Now, what I learned out of my experience with DNA fingerprinting, one of the things I can surely say is that technology is one thing, and IPR procedure another. So as scientists, as researchers, we tend to put a lot of emphasis on technology. But when we apply this for legal protection or for IPR purposes, I think that the story is quite different. For example, for maize, I've been working quite a bit on EFLP technologies in Netherlands. And of course, I've been using SSR markers also. So when I had to replicate the same work on maize in India, the problem I encountered was that, to start with, I could not use AFLP markers because they were charging. I came to know that there are patent issues involved. So they are charging upfront fees, which was quite a bit, and then there was a running fee. And the upfront fee for maize itself meant that you have to pay a lot of money before you can start. So for even for a private sector company, if you want to do one isolated project, you have to shell out that upfront fee, which was not a possibility in our case because the patent fee for EFLP was quite high. So one of the technologies which I was quite comfortable with, which is the EFLP technology in 1990, in the year 2004, and which was pretty much at the top of technological circles, this could not be used. Similarly, we had to move on to SSR markers. And in that case also, SSR markers, you see, the issue was how many markers are required. And so those sort of things had to be sorted out. And before I go into what technology I used, well, it was SSR markers, I also must say that when we are doing DNA fingerprinting for varietal protection, one of the criteria is that the technology should be freely available and freely usable. So you take something like EFLP, which many of the labs across the globe cannot use. So you cannot use the advanced technologies if they are expensive or they are not accessible enough in order to DNA fingerprint your varietal, your material, your crop varieties. So obviously, so that was another hitch that we encountered, and that was the reason when we stuck to SSR markers and also how many numbers of marks. Now, why I'm saying this is, again, coming back to the same point, that as researchers, as students, this is basically less for the senior ones, but more for the budding scientists. The technology is one thing, and when we're talking about using the same technology for, in industry, the IPR angle has to be looked at, and that is something pretty much requires an expertise. So that is where the IPR issues, they have to be looked at, and it's not so. So that's the only thing I want to say, that it's not as straightforward as learning a technology and putting it into industry. Okay. The second thing, when we say we are talking about the biotechnology in IPR, I would say the molecular diagnostics is the second most important thing. Of course, the molecular markers are also, just the way I said for DNA, DNA fingerprinting, we use molecular markers, but for many other purposes, techniques like DNA barcoding, ELISA, immunoassays, strip tests, microscopy, or microbiological culture, all of these biotechnological tools, they are helpful, they are required to understand the presence of organisms or biomolecules. So these are the technologies where biotechnology can help IPR perform its duties. Now I do the reverse run here, and that is so far it was the biotechnology in IPR, but now I come to IPR, how IPR helps biotechnology. Excuse me. Dr. Thakur has already touched upon the issue of how turmeric was prevented. So I shall be when we talk, so like I said, I shall be talking about some of the issues and case studies. So when we want to protect our assets, the biological assets, which could be the crop species or which could be the biological processes, one is we protect the complete plant, for example, turmeric. But then there could also be just the individual genes. For example, and I'll come to this point later on, so we could be protecting the total plant, we could also be protecting the genes, and then we could also be protecting our traditional knowledge, for example, the Ayurvedic wisdom. Now, so these are the issues I shall be discussing in the subsequent slides. And apart from that, I would like to highlight that IPR is a double-edged sword. And what I mean by that will be more clear when I talk about some of the issues. For example, by Monsanto, very recently there has been a little bit of a tussle between the government of India and the multinational company Monsanto, which is being acquired by Bayer Crop Science, as far as the royalties for the gene crops are concerned. So I shall be discussing about this issue, and also about how one more crop, a hybrid mustard crop, which has been released, which was attempted but not released. So I shall be discussing how the IPR issues have impacted these industrial efforts. Right. So again, I'm sure by this time basics about what happened to turmeric has been already been indicated by Dr. Thakur, but this was a patent granted in 1995 to two researchers from USA, and they covered the so it was basically formulation coming out from haldi, from turmeric. And this is what and what they claimed was that this formulation can using turmeric powder can heal surgical wounds and ulcers, and this was countered by the scientific community from India, and successfully we were able to stop that patent from happening. So that's one of the reasons why. Again, so that in this case we are talking about a total species, but again, when we are talking about protecting our biological wealth, we are even within the same species or related species, there's a lot of germplasm that needs to be protected. For example, in this case, this is potato. Now, potato is not native to India, but this is just an example, and we can see that there's so much diversity within potato. When we do potato crop variety improvement, all of these genes, all of these characters will be incorporated into the varieties, and that is how new varieties are produced. So if these, so using this, even within the same or related species, you see there's a need to protect the germplasm, and because that's the way to produce new species, and how IPR can be deployed to protect that heritage is an issue that needs to be studied, and that's something that needs to be looked into. Similarly, another point I would like to highlight is this is also why biodiversity is so important and why IPR is extremely important. Again, like I said, I'm not going too much into details of how to do it, but I'm saying more about what needs to be done. And because since I'm speaking only from the angle of a biotechnologist, like you say, I mean, what I want to say in this slide is that a single gene can make so much of a difference. We all know the Green Revolution. And in the case of Green Revolution, it was just one gene, or not one gene, but related, it was a single gene family of related genes, which could shake the world, agricultural world, and make so much of difference in alleviating the poverty from globe. So in this case, it was just the dwarfing gene. So obviously, let's, in the same breath, I would like to say that we must take into account that you see it's the developing countries who are who have the biodiversity wealth, and it is the developed countries who have the technologies. So obviously, this is a sort of paradox. This is a sort of dilemma we encounter quite often. People in the West, people in the advanced countries, they have the technologies. And this is what we do. And in the subsequent slides also, this sort of paradox or this sort of dilemma will be quite visible. Monsanto made BT cotton. They came here, they made a lot of money, good for them, perfectly fine. But the thing is, this is a sort of a pattern that happens so often all across the globe, that the technology lies with the developed nations, but the biodiversity lies with the developing world. And this is where I want to say that, again, Green Revolution happened because of just one gene family, and that is the dwarfing gene. And it's only a question of time. Somebody from the developed nations is going to pick up some genes from our germplasm, and those same genes will be thrown back on us, and they will be making, they'll be encashing upon our market to make money out of us. And then the point is, we have to be ready for that sort of IPR setup, so that we are in a position to to think about benefit sharing, in a position to think about and this will be more clear when I talk about what happened to the Monsanto, to our BT cotton. So in this slide, all I want to say is that a single gene can be earth-shaking dimensions, and make a lot of difference to the agriculture scenario all across the globe. Right. Now, another point is because genome sequencing is becoming cheap, and this is becoming commonplace, a lot more novel genes will be discovered. So this is all the more reason we have to be ready with the IPR apparatus. And not just that, our scientific community and our budding scientists, they have to know what they're doing, and how to protect their knowledge, and traditional knowledge, and also the work. Fine. Now I'm taking one of the current issues, and then we are talking about the effect of let's say what the coronal kit did to the COVID-19 pandemic. Now, these things could be debatable, but before I talk a bit more about this slide, let me move to the next slide. Here is some clips I got from Amazon and 1mg sites. And this was about, apart from that, of course, we all have been discussing with our friends and family about what the coronal kit from Patanjali does. And this is from Amazon. You can see there are, let's say, there's a rating by 44 global ratings, and they have rated it 44.5 out of 5. In this case, in 1mg, there are, let's say, 388 ratings, out of which, in both cases, the rating has been something like 74% and 75%, and that is an extremely high rating. Now, based on our experiences, what we learn from our friends and family, and what is visible from sites, from data being collected by not Indian but international channels. Like Amazon is not Indian, and still the data is quite visible. So obviously, there are quite positive trends coming out of Coronel. Now, I'm not making any personal judgments here, but the point is, these are the one thing I would like to say is formulations and protocols can be patented. Why not Ayurvedic formulations? Now, since we have listened to the talk by a very learned talk by Dr. Ajay Thakur, this is quite a gray area. Now, can formulations and protocols be patented? I will keep my fingers crossed, but I'm sure the biological process can be patented. So there's a bit of a gray area. So, what is the biological material? And for example, let's say even the coronal kit itself, I mean, is it proprietary? And, can somebody just copy it and use it? So again, there's a lot of traditional knowledge involved here, and also there's a lot of, and not to forget that Ayurveda is a 1,000+ year old philosophy or a knowledge bank which we've been having. So how IPR can be used, to protect our traditional heritage? Now that is something I think all of us who are into the area of biotechnology have to think about, and this is something that needs to be catered to. Again, some of the issues, there are big gaps here. These are the things. Exactly, this is the point I would like to highlight at this forum. Is you see, there has been even recently there has been quite a standoff between the Patanjali representatives and between the allopathic representatives. Now, where does Ayurveda stand? And should it have acceptability? Part of it is, again, we are talking about using our traditional knowledge, and does it? Now, again, some of the questions are scientifically valid trials being conducted? And are they how are they really scientifically valid? And if yes, are they why are they not commercially relevant, and why they are not accepted? So obviously, how Ayurveda and how allopathy can complement each other, and again, what the role that again, so IPR will have quite a role in not only protecting our intellectual heritage, but also to make it complement or contribute in a substantial way to the existing allopathic methods. So I think this all does. So IPR does have a role to play when we are talking about using biotechnology and and protecting our traditional wisdom and also our biological material. Okay. The next point I would like to discuss is the case I would like to discuss is recently there has been quite over the past over 1 decade, BT cotton, the GM BT cotton was released in India. And we all know, before we go into what happened and where we are at this moment, let's be very clear that the BT technology or the transformation technology as such is quite robust. Now, this example on the screen is an example of is a picture of 2 crops. One is the BT cotton and the other is non-BT cotton, which have been sown side by side. And we can say that in one case, and in one case, the heavy pressure of the insect pressure was given, and in one case where the sprays were made, we see cotton is abundant, and it's the plants they grew healthily, and there was abundant cotton. Abundant cotton balls being produced. But in the other case where which was non-BT, there's almost total damage. So before we go into the BT technology or before we go into the transformation technologies, I think one thing is very clear that regardless of the ethics, regardless of the regulatory, procedures and the acceptances or suspicions, one thing is sure, that the technology itself is sound and it works pretty well. Now, at this forum, I would like to discuss, what happened to Monsanto came to India in 2002. And obviously, some of the major highlights are that there was a market monopolization and how India is dealing at this moment. So we will be discussing about expired GM patents, and we shall be discussing about the generic products. And we shall also be discussing how the indigenous local seed companies are reacting to it. Right. Now, before we do that, let's have a look at what happened to the pricing and how things changed over time when the beauty cotton came to India. Beauty cotton came to India in 2002. Till 2006, the price of ball gourd 1 was 1600 rupees. Till the time, the government sprang into action, and then they reduced the price from 1600 to straight 750 rupees. You see, I hope my voice is, I'm audible. Can somebody let me know, please?
Yes, sir, you are.
Okay, yeah. So we can see that from the year 2002 and to 2006, nothing happened. What were our IPR people doing? What was the government doing? Nothing. And we had no idea that somebody is gonna monopolize us, and we had no idea how to control the pricing. So, and the moment somebody woke up from 1600 to 750, and we are talking about, they were making something like $1 billion plus from India, which is perfectly fine. If somebody does something good work, they have every right to make money. But the thing is, from 2002 to 2006, we were doing nothing. We were simply, there was a total monopoly, and we had no idea what had struck India. Something good was happening, but then we didn't have to really pay that sort of a price. And here was a case where there was total monopolization, and we didn't know how to react to a technology which had been thrown open to us. So in the year 2006, there was a drastic reduction of price which Monsanto Mexico were charging from 1600 rupees per package to per packet of 450 gram to 750 rupees. Okay, now let's, in the same breath, let's also be very clear that out of these 1600 rupees, the price was only, like they say, okay, it's not mentioned here, but 2/3 of it was just the royalty. So that means the actual price of the seed, the hybrid seed which was being produced, was 1/3, and the royalty was 2/3 of it. So that was a huge amount. Now, that was in the year 2006. Again, so from 2006 to the year, I guess it was 2020, then again the government sprung into action, and it was in the year 2020 that the royalty on ball gourd 2 BT cotton was totally dropped. So one packet was worth 730 rupees, and like the company who brought in the technology, Bayer Crop Science, they were told to that they are not they cannot have it. It's sorry, that it is an old technology, and we cannot pay you the royalties anymore, right? So again, the take-home message. Okay, before I go to some of the. So obviously there is some learning. So what we can notice from this trend, what happened during this period of 2002 to let's say 2020, it's roughly 2 decades we are talking about. So we were a confused lot, and somebody came and monopolized us. And our IPR people, even if they knew, they were silent and they could do nothing from the government. And with all the due regards to our highly efficient IPR guys, the time was there to speak out, and we were silent. And you see, it's not just that, but also you see, it's also about checking the monopolization. So it's not just IPR. The greater issue is. Again, we are talking about biotechnology, we are talking about IPR, and we are talking about industry, a lot of the industrial issues. So all of these things, the reason I'm saying is that all of these things are connected, and at a later stage, I may not be able to go deeper into how research is funded, but at some point, when we grow higher in our career, when we're talking about grants and we are talking about research, all these things are related. Fine. Now, before we go into some more, soul searching about what happened, let's also think about, how much money Monsanto spent before they made the GM products. Okay, you see, this is according to the figures of 2013, the R&D budget of Monsanto was $1.533 billion. Syngenta, another multinational company, the budget was 1.37. So we are talking about a budget of the order of $1.5 billion. And what can an Indian local seed company afford? Here is the figure. Our average seed company has an R&D expenditure of $2 million. And I'm talking about 2013. Now, can we ever compete $2 million with roughly $2 billion, 1,000 times gap? And let that sink in. So it's very clear. We cannot have the money. We do not have the money. Our companies do not have the money which they have. And look at the time, 13 years. They have deep pockets and they have the money and they have the resilience to go into research for 13 long years before the product is delivered. Indian companies cannot do that. Okay, now that is about the R&D budget, and that is about the time it takes to deliver one transgenic crop with just one transgenic trait. But what is the money which is involved in commercializing just one crop with one trait? The figures are about at least $136 million. Now, for just one crop and one gene or one trait, we are talking about $136 million, when for the R&D budget of all the crops, for all the research expenditure put together in an Indian seed, medium level seed company is $2 million. So obviously there's no way the Indian seed companies could, or even today, I'll come to that point, to go into that. No, I'm not discouraging the Indian companies for going big and investing a lot of money in research and doing some proactive research. No, that's not the idea, but we have to be practical. So I move to the next slide. Right. Oh, sorry. Okay. Now, before I go into, so that was just one thing, I talked about the time and I talked about also the money involved. But let's talk about the technology involved and how big the teams are. When many of us here are specialists in GM technologies, and even without going into the details of or knowing the details of how genetically modified crops are produced, I should give a brief overview of what all those what are the departments which are. Now you got to identify, isolate, and characterize proteins of interest before you go into gene isolation. So we are talking about protein chemistry. So we need to have a laboratories totally dedicated to protein chemistry. Then we make a gene construct. We are talking about molecular genetics. We develop the transformation and regeneration protocols. We are talking about cell and microbiology. Then we transform the crops of interest. We do the expression analysis, copy number analysis, insert size, sequencing, and a lot of sequencing of the inserts, and then elite event selection. We are talking about again cell and a lot of molecular biology. Then we are talking about a lot of extensive environmental and biosafety testing. We are talking about field testing. We are talking about trials with animals. Okay, so that is where even the animals and animal testing comes into picture, another department involved. Regulatory approval for multiple governmental departments. You're talking about Ministry of Environment, Ministry of Health, and Ministry of Agriculture. These huge these ministries involved. Integration of gene of interest into elite lines. We are talking about plant breeding, and then developing hybrid varieties for commercialization. We are talking about plant breeding. Okay, now what am I saying here? let's come to the bottom line, which is visible here. I think we need to be street smart. When you cannot compete the big guys in money and technology, do what has worked so far. Go generic. Now, what I'm trying to indicate is I'm comparing agri-biotech with pharma. So what we have done in pharmaceuticals is something very similar, and that has worked. We all know India has made a lot of money, and India has done a good work. I mean, nearly 13 or 17% of the drugs market, the drugs which are being medicines which are being sold all across the globe, they come from India. We didn't, I mean, if you look at the R&D part of it, we didn't invest a lot of money or our efforts into R&D. We did all these things like, companies like Ranbaxy and Cipla and all these. I mean, in a major part, their products came out of generics. So I think a very similar, I mean, again, what I'm trying to indicate is we need to be street smart, and a similar sort of things has to happen here. I mean, whether or not, I mean, I don't say that R&D efforts should be stopped, but the thing is what works, and why not? And that is what is happening already now. The patents are expiring. I mean, Dr. Thakur gave a very good indication, and there was a great question which somebody said that how do we know which patents are expiring when? And the answer, which in fact I was also looking for that answer, and the answer which was delivered was that look, officially nobody is allowed to tell you when which patent expires, but we can have a rough guess, because when the product comes into market, already we know, then it's there in the news. Already we know that this sort of product is going to be valid. The license is going to be valid for that's 20 years or something, and we can be ready that okay, that's the time when the patent expires. So I think that is what has to be done. I mean, I don't want to sound mean, but that's how it works, and that is what a lot of companies in India are already doing. I know one company, for example, the Kalash seeds. Okay, now what the government, I mean, we look at, see, here was an example when one company was bullying us. Okay, a lot of, and they were not ready to listen to us. And we all know that in the past couple of years or 1 year, there has been a good standoff between Monsanto and the government of India. And the government of India, I would say, they did a good job. I mean, they took a stand. And they said that, okay, I mean, if you're not willing to, that we don't give you the I mean, they cut down on the royalties drastically. And in fact, in one case, the BG2, the royalty was totally cut off. Good or bad, that's again a topic of controversy. But the thing is, monopoly has to be checked. And, what works, it works. And what we are seeing here is what Kalash Seeds has done is, to the best of my knowledge, they're using gene constructs, they're using genes which are now expired. And why not? I mean, even if the gene is expired, I mean, the insect dies. It's very much valid today. What the protein, or let's say the delta antitoxin, or the BT protein, which killed the insect yesterday, if it kills the insect today also, why not do it? So that is, it's not just Kalash Seeds. They have got a very key approval from the regulatory authorities, but many Indian companies are now in the fray, and they are now in the queue, and they are getting those transgenic varieties released, or they're getting deregulated from the regulatory authorities. So who loses? I think Monsanto, to my knowledge, I don't want to sound, again, these are personal views. I think, they got a message, and that India is a big nation, and that's what we are. And I think till the time we put our foot down, I mean, nobody can bully us. It's as simple as that, plain and simple. And I think this is the first time, that's when you see the power of being big. And why not? Use it. And again, it's not only about being street smart and using your powers, especially when somebody is bullying you. And I mean, I don't want to sound too pushy there, but the thing is that this is what has happened, and this is what has worked. So again, coming back to the IPR issues and biotechnology, the point I want to say is, again, for our biotechnologists and for our policymakers, for the past 20 years, we've invested a lot of effort in doing research into transformation. I've been visiting a lot of universities, And I've been talking to also, many of us have been, are aware of a lot of huge groups involved in transformation. And trust me, I've seen many of my friends, senior friends, who've been frustrated, ever since they entered transgenic research, and they have to drop it. The reason being, in the past 20 years, I mean, it's a shame, it's a real shame that we did not bring out one transgenic product which was originally Indian. Why? I mean, you work on something for 20 years, you invest all your money, and at the end of the day, what comes out is nothing. There's no gene. We don't have any one gene, any one protein which was sort of earmarked for making the transgenics, and we don't have any one transgenic product where we can say that we started from scratch, from the protein, identifying the protein, and we went up to the finish. Nearly 20 years. So you see, there's a message also for the policymakers. You see, and where to orient our budgets. And also equally important is for the budding scientists in the audience here. When we are looking at how to orient our careers, I think IPR is quite important. So having an idea about which way the winds are flowing, and where we stand in case of IPR, does it make sense? No. Okay. No. Let me be very honest here. What happens since I've been into molecular breeding? If you ask me today, and what has happened for the past 10 years is, you don't really need to do all the transgenic. All you needed to do was get the transformed lines from Monsanto and then start back crossing them into your lines, and that's it. You get the product, you have your hybrids with the gene there, and you start selling it. Okay, and that is the reason our scientists who were going into transformation spent a lot of effort, and trust me, many of them are broken because they invested their career in developing, in learning the transgenic technology. But at the end of the day, what was required was simply a little bit of breeding. All you have to do is cross your, let's say, BT lines purchased on royalty from Monsanto, cross them to your own elite lines, and you make a hybrid. So all you have to do was simply crossing. You don't have to do anything related with the basics of transformation. Okay, so, and that is where you see, I mean, even though I might sound, I'm not berating any technology, but the thing is to be street smart. These are the issues which not just the government, but also the budding scientists have to know which way the technology is heading. What are the technologies that deliver? What are the technologies, at what level we have to pick them up, and what is it that is commercially viable? So, and I touched upon this. I went at length in discussing this area because this is relevant to our to the national market, to the national money, to national capital, to the national policymakers, and three, to the budding scientists. So I think that sort of gives a take-home message about what I want to deliver. Right. This was, the above case, like in this case, was this is where, for example, the Kalash Seeds and some other companies, they are doing a great job. They have picked up a gene, the patent for which is expired. They are putting into their lines, and they are about to make good money, and they've been accepted. And I think they're on their way to do some good business. But now let's talk about the bad decisions. Now, again, I don't want to, I don't know. I'm going to talk about something. The DMH11. This was a GM mustard hybrid, which was launched by the group of Professor Deepak Pentel and at Delhi University. Now, again, if you see, I have written in red words. Was it a bad example? No. Why do I say was it a bad example? Fine. This group of Dr. Professor Pentel, with all the due respect to his caliber, which nobody would ever doubt, and I mean, they used an expired patent for the mill sterility system of Barney's Barstar, which has been developed by the Belgium-based groups, PGS Ghent. But since the patent was expired, they used the patent to develop a hybrid variety in mustard called the DMH11. But the trials were not for when the product is there, when you've made the transgenic lines, and when it's the time to commercialize it. Obviously, you have to do field trials. At the stage of field trials, what went wrong? I mean, this whole project was dropped. Was it because the public was not willing to accept it? there was a public sort of reluctance to getting GM crops, or was it because of regulatory hitches? Now, if you look on internet, if you look into news, a lot of people are saying that there were a lot of questions on the on the field trials. I mean, why? The thing is, my question is, as a member of the public, is a lot of money has been spent on this project. A big group from a big Indian university was involved for many years for bringing a very major project to fruition. And just when everything is ready, and when the thing is out, the product is out for trials, it's ditched. I mean, is there any need for sort of a public accountability? Why was this project? I mean, was it? I don't know. Was it ill designed? Things like public reluctance, regulatory hitches, they could have been thought even before the project was taken in. So what I'm trying to say is, just because of hello, how much time do I have, ma'am?
Sir, we have around 15 minutes more.
All right, okay. Okay. So, so let me be quick. And so the big question is, I mean, the people who are in power, people, the big professors and the policy makers, when all this money is there, I mean, who questions them? And can you really ditch big projects just like that? And the second thing is, then another thing is, just because a patent is expiring, does that mean that you pick it up and start publishing papers on it? That look, we have used this thing, we have used this construct, and I mean, is it meant? So again, the issue of misusing IPR and misusing the system needs to be sort of discussed. In public good. So that's another idea. I think so that's some of the things which probably the budding scientists, not just budding scientists, but the whole of scientific community should be concerned about, right? Okay, IPR for students and researchers. One of the things I think which Dr. Thakur very nicely, very rightly mentioned was that the awareness about patents to students. To be very honest, I've spent at least 10 years doing research which was never patented. But today I feel there were times when I was working on things. For example, the transformation protocol for UCRA, which I was working on. Some of the things could have been patented, but the thing is, many of the students or many of the startup early researchers are never aware about the patent process. The thing is, I mean, getting patents is a process of clearing a methodology. It's not about doing big research. See, I mean, it's very clear. I mean, you can have a technology, people who move up the ladder, whether in academics or in industry. I'm being very practical about it. It's not about doing big things. Many times it's being about practical. Again, patents. Many of us do things which are never patented. And patenting can be more of process. It can be more a question of understanding the process of how the things are done. So even if your discoveries, your inventions are not very big, even if they are not very worthy, you can get the patent and that goes to your CV. Okay, and even if you've done good work, you're not able to protect it and somebody else uses it somewhere. So I think, and these are things which I've been going through, and these are the things I think, and there was a time, to be honest, there was a time when one of my friends told me years down the line that, look, Rajiv, there is a protocol which you made and you give it to the company, and the company put it into the cold freezer. And years down the line, the same protocol was given to me, and I was asked to do the same protocol and see if it really works, and it worked. And my friend was very, very honest, and he made a phone call like that. Look, Rajiv, but it's gone. I mean, it's your effort wasted. But the thing is, it may not go to your credit. But the thing is, the protocol you gave worked. Now, the point is, when you're working with the companies, when you're working in private sector or working with the government, I think the students have to be very aware about the patenting methodology. And that's how you get the credits, right? So knowing the broad patent process is extremely important. And again, protecting your discoveries and inventions. I'm going to conclude it now before we move into. It's not a big presentation, but the thing is, I have made only few points here, and my conclusion that Firstly, we have discussed the role of biotechnology, basically, which was DNA fingerprinting and molecular diagnostics, how they can complement, how they can support IPR issues. So obviously, that's what that's what connects the biotech students or the biology students with the IPR issues. And secondly, there's a need for specialized biotech expertise for catering to IPR. It's not just that you learn a technology and you say, okay, that's good enough. You can go to industry and use it for IPR. No, that is a very specialized area. For that's what I learned the hard way. I thought I had got the training from Holland. I can simply come to IPRISAT and simply do the IPR protection for DNA fingerprinting for maize. I was so wrong. The technologies I initially started with, the AFLP markers, they were just not usable. So I had to move to SSR markers. And I think it's the same with all the students or all the budding researchers, the PhD students. I think keeping an eye on the IPR issues, how far your technology can be used in industry, I think that's quite vital if the training and the research have to carry due meaning. Right. Then we discussed some cases. We've discussed some cases, and we have discussed the role of Ayurveda in COVID-19 control. So a lot of data is now coming, and I think we should not really, that is the positive thing coming out of COVID-19 control. And I think in a way, Patanjali has done a great job because they have brought out a product in the name of in the form of Coronil, which can be which is now open to trials and real-time trial by the people across the globe. And so if that works, I think this is something which will be, that will set the trend for how about other Ayurvedic protocols and biomaterials. The other case we discussed was about the Monsanto monopoly and how the government of India, they both had a little bit of a standoff, and how we should be directing our industrial sales and IPR issues accordingly, and how to stand up to sort of monopolization, international monopolization, and use the force of your the big nation and add to and save your farmers and use the same the same power towards helping your farmers. The next case we've discussed is about the turmeric, and also we've discussed the case about I would call it a bad use of expired licenses. So I think that is where some accountability is required. I mean, somebody can't just start a project and use a lot of money and ditch it. So I think that these are the issues, some of the issues which I brought up, and we are now open for discussions. Thank you.
Sir, thank you so much. I think this was a revelation to me as well, because you've given us so much practical knowledge regarding biotechnology, patents, etc. So when we do our research, this is something that we can definitely think about. So thank you so much for that, sir. I can take a couple of questions if anybody is interested. You please feel free to ask questions to sir for a few minutes.
Sir,
listen.
Is there any special? Is there any special or different group in the pharmaceutical company related to patent and their renewation?
IPR in pharma, I'm sure, yes, definitely. That's a very good, very valid question you have raised, actually. So whether it's pharma or it's agri-biotech, there is, there's surely there is a niche. There is a niche for professional excellence, and there is a need for expertise. But at this moment, I'm afraid I cannot give you any leads into what are the groups and who are specializing in IPR. And that's a very good idea. That you remind me about a discussion I had about IPR in way back in Germany in 1998. And I think, those things are sort of missing in India. And I think, okay, no, may I know your name, please?
Sir, it's Padmanabh.
Padmanabh.
Yeah, yeah. The thing is, I mean, see, it's the very similar issues with the, at this moment, one of the burning issues is genome editing. And again, genome editing in many of the nations, for example, America, USA is totally in the favor of genome editing, and the European nations, they are not so much in favor of genome editing. So there's a little bit of a tussle going on, but they both have taken a stand. India is confused. We still have not decided. I mean, how do we deal with genome editing? No, it's only now that realization has dawned. But the thing is, a lot of developed nations, they are far ahead of us. So I think you are very right. There's a need to have some sort of expertise, specialized expertise when it comes to, when it comes to having trained manpower, expert manpower, knowing how to apply IPR either into pharma or agri-biotech. But to my knowledge, the country lacks there, and you guys could take up the cudgels. And I think that's an area which needs leaders like yourself. Thank you.
Thank you, sir.
If there aren't any more questions, could I please request Dr. Rishikesh Dhanve sir to conclude the session and give his remarks, please.
Okay, thank you, madam. Am I audible?
Yes, sir, you're audible.
Okay. Good afternoon, all of you. I am very honored to present before you the concluding remarks of today's webinar on IPR patents, frontiers and opportunities. As we were sure of, this has been one of the excellent webinars among the series of online webinars organized by our department. Realizing the importance of this topic for all streams, students from all the different faculties, researchers from arts, commerce, science, these different fields were promoted for the participation in this webinar. As we were very happy, very happy to receive an overwhelming response of over 300 participants from different streams and fields. This webinar was conducted on the virtual online platform using Zoom meetings and was also streamed live on the YouTube for the participants and viewers out of the constrained limited access. First of all, we are very happy and we are fortunate, and at the same time, we are very grateful to have Dr. Ajay Thakur sir for having him available for today's seminar. It has been a continuous support by Dr. Thakur sir for us. Sir has guided our students and participants in past also through his excellent talk and discussions in the national conference organized by our department in year 2020. In today's talk also, sir has elaborately and specifically focused on details of various related aspects, especially in frontier fields of applications, fundamental concepts and terminologies, opportunities, processes involved, and at the same time, the challenges also in the IPR and patents. On the other hand, we are also very fortunate and grateful to Dr. Rajiv Tagar sir for having available today. Through his excellent talk, sir has very effectively discussed the role of biotechnology in intellectual rights protection, which has been a very informative source, especially for the participants from the field of biotechnology. Sir has very aptly emphasized on the importance of effective protection of intellectual heritage, as well as traditional knowledge and wisdom in various fields. With this availability, certainly we are looking forward as an excellent initiation in support of our recently established MOU with SciCab Mohali for the benefit of students, researchers, and the future budding scientists. In conclusion, I find today's talk and discussion very effective, informative, resourceful, and beneficial for all the participants. Indeed, as expected, today's webinar has been a very successful event, which has given all of us an inspiration and the confidence as an organizers for such events in the future also. Especially, I take this opportunity to thank both the honorable eminent speakers and also to thank Principal Dr. B.N. Kamble sir, Head of Department Mrs. Gopika Manjunath Madam, and the entire organizing team, especially for the technical aspect, which as usual was perfectly handled by Dr. Chitra Naidu Madam. With these words, I would like to conclude here and declare today's program as a very successful event. Thank you one and all. Take care. Stay safe.
Thank you so much, sir, for those wonderful words. We are about to conclude the session, and before we conclude the session, I think we would just like to give our final thanks to everybody. And for the vote of thanks, could I please invite our Assistant Professor Shweta Shikre, ma'am, to give the vote of thanks, please.
Good afternoon, everyone. Is my voice is audible?
Yes, sir. Audible.
Good. Okay. I'm honored and lucky to have been opportunity to propose vote of thanks on this special occasion on national webinar on IPR and patents, frontiers and the opportunities. On behalf of the VG Shudare College, Arts, Commerce and Science, first of all, I extend my very warm welcome to all and thanks to all.
The recording is recorded.
Who present for this webinar. My special thanks to the speaker of today's talk, Dr. Ajay Thakur sir and Dr. Raju Taggar sir. Thanks to both of you for your valuable time and sharing excellent presentation with immense knowledge. My thanks to our chairman, Shri Rashekar Shivdare sir, for his support and to conduct such a programs. My thanks to our trustee, Shri B.V. Shetty sir, for his valuable support and the guidance. My thanks to our beloved principal, Dr. B.N. Kamre sir, for his valuable support and the motivation to organize such a programs. My thanks to our dynamic Pro Vice Chancellor for giving support in organizing this national webinar. My thanks to R.Y. Patil sir, Principal, College of Pharmacy, for always being a guide and advisor. My thanks to Sri Kilje sir for his guidance and support. I am very happy to express my vote of thanks to our beloved HOD, Mr. S. Gopika Majunat ma'am, who always tried to show the right direction to the career by organizing such a wonderful events for the students. I am very heartily thankful to Dr. A.M. Deshmukh, President of Microbiology Society, Dr. Parshuram, Dr. Yadav sir, NBPGR, New Delhi, Dr. Jyotsna Sharma, Director of NRCP, Dr. S.B. Gaikwad, Professor from Walchand College, Dr. Dhullab, HOD of Earth Science Department, Solapur University. Thank you all for your advice and support. Last but not the least, the students who have participated from city and out of the city in a large number, I thanks to all the teachers, all the respected teachers, academics, research scholars, I thanks to all for making this webinar grand success. Thank you very much.
Thank you so much, Shweta ma'am. With that, I would like to conclude this session, and you will all be provided with a feedback form via your email. If you could be kind enough to fill that out for us, that would be very helpful. So thank you, everyone. And this is the end of the session. Thank you.